as well as prevention, as the Prevention of Organised Crime Act, number 121 of 1998. Your Lordship will remember that racketeering prosecution can only be instituted in special circumstances, and only the National Director of Public Prosecutions can, in terms of the Act, issue such a or authorize such a prosecution. In terms of the order of the indictment would need to be reviewed to exclude the first and second respondents, as well as the number of charges that were only applicable to them will need to fall away. It will be respectfully argued that the order in respect of the second prayer has the same effect as where an objection to the indictment was upheld, in that the indictment needs to be amended from the original on which the respondents were arraigned. Lordship, and in that regard, I want to take you back to section 3192. And that reads, the grounds upon which any objection to an indictment is taken shall, for the purpose of this section, be deemed to be a question of law. So the point I'm making is, Your Lordship, is that apart from the effect or the effect of the order that Your Lordship issued or granted in this matter has a material effect on the indictment that's going to be before the court. Of course, it takes away accused, it takes away charges. Your Lordship,
what is the difference between that situation, just the situation of
Mr. Matotsi pleaded guilty, Your Lordship. The matter against him is finalized. And Your Lordship will remember, we then amended the indictment.
What is the difference?
Mr. Matotsi will come and testify in the trial, Your Lordship. So his evidence and his version is still going to be there.
I'm talking specifically about the separation of issues between that. If we did that in what we did for you doing
Your Lordship, there was a purpose therefore, because he pleaded guilty, whilst the rest of the accused indicated that they're not going to plead guilty. They're pleading not guilty.
The purpose is that they will still be to proceed with the trial eventually.
No, Your Lordship.
General purpose? Not
Your Lordship, it's not the same. It's not the same. Because Mr. Matotsi pleaded guilty, the matter against him was finalized. So the matter against the other accused, we started with 14. We actually started with 15 at some stage because there was a Mr. Tutter, also previously pleaded guilty in the lower courts. But the indictment before the court on which they are arraigned includes all of the accused and all of the charges as set out in the indictment that's before the court. Your Lordship, and on this point I just want to dwell a bit on the interlocutory issue, because both Mr. Abrams and Mr. Struer made something about the interlocutory nature, and they refer back to the matter of Mr. Msiza, who previously applied for a separation of application, and leave to appeal was refused, and the court said it cannot be granted because it's interlocutory.
Was it the court or you argued, Mr.
No, in the judgment, the court on that basis said. Yeah. Your Lordship, but it was a matter before court. But they asked this court, they say, Your Lordship's order in this regard remains interlocutory. And the point I want to make, it is not the same. Because the interlocutory application can always be revisited. But Your Lordship's order is final. It cannot be revisited. The only court that can revisit it is if we go on appeal. But the trial court cannot revisit it. If the trial proceeds and down the line the court says, oh, I should not have separated the trial. We cannot go back and add it. It's too late. The only time we can address that issue is now, before we move further.
This court cannot reverse what has been.
That's correct, Your Lordship. Your Lordship, now, my argument in this regard is the effect of the court's order is that, and that's paragraph 24 of my heads of argument, is effectively that the court interferes with the prosecutorial prerogative as how the accused should be charged as provided in section 179 brackets 2 of the Constitution. Effectively, the second order of this Honourable Court deprived the applicant its constitutional right to institute prosecutions as deemed fit. And in this matter, I want to refer Your Lordship to the matter of Reis versus Director of Public Prosecutions, Western Cape and another. Your Lordship, it's a matter that I already referred the court to when we argued the matter. Court, just give me one moment. I've got it, my Lord. All right. Reis versus Director of Public Prosecutions, Western Cape and another 2021. Volume 2, SACR 140. It was a Western Cape division matter at page 157. That's correct, Your Lordship. Paragraph 59. And I want to read the passage. The Court of Co was effectively being asked to interfere with the prosecutional prerogative. To take such a step would surely have involved the court preaching the separation of powers principle. But in any event, as Ponan J.A. pointed out in the passage referred to above in Dos Santos, paragraphs 12, 40 and 43, the prosecution has a wide prerogative as to how and where it chooses to charge an accused person in a poker matter. Your Lordship, in my heads of argument that during the application and in court, I address your court fully about the Prevention of Organised Crime Act. I showed you, took you through the preamble of the Act. indicating that the constitutional weight and the importance of the Prevention of Organised Crime Act, and why that powers are given to the National Prosecuting Authority to make use of it, and why it's in the interest of justice. It's set out in the preamble of the Act. Your Lordship, it must be read with section 157, and there's case law that I referred Your Lordship to, which I will get to now. It's important. It cannot be just treated as section 157 used to be treated. There's extra considerations when you deal with the poker matter. So maybe I can take your Lordship to that cases.
And when you deal with the poker matter, do you ignore completely the provision of the Constitution? Fair right?
No, Your Lordship. The thing about the Constitution, and there's a lot of case law which I referred you to.
Yes.
During the application about, the fundamental rights as interpreted by the Constitutional Court and by the SCA. Your Lordship, all the submissions we made were based on interpretation of the apex courts in this Republic of South Africa. Lordship, and the thing is, there always needs to be a balanced approach. That's how the Constitution works. You need to look at everything. And that's our argument. And I don't like making it, Your Lordship. For the court, I would rather, the heaven knows, I would rather finalise this matter, but I would be neglecting my oath as an officer of the court and working for the National Prosecuting Authority if I don't act in the interest of justice. And so it's, and the crux of our argument is that Your Lordship's approach was not balanced. It ignored the fundamental rights of the community at large for cases like this to be prosecuted in the manner that we prosecute them. That's true, Your Lordship, but you must do Your Lordship. It's something I argued during the application. Sometimes you cannot take shortcuts, because shortcuts is not the right way. You need to take the long, follow the route. And this case, there's a lot of ramifications. We set it out in our papers. We set it out why it's necessary that we put the whole body of evidence before the trial court, so that the court can consider everything, how this whole thing worked. And we are being deprived of that if there's a separation of trials, in that we cannot give the whole picture. And Your Lordship, as much as wants the matter to be finalized, they also want it to be done in the right way. Your Lordship, I'm going to refer you to a couple of cases dealing with racketeering, the separation of trial applications where racketeering matters are concerned. The first court matter I want to refer your Lordship is the matter of Maringa and another. 2015, Volume 2. SACR 629, SCA Your Lordship, and there's a number of paragraphs I want to refer your Lordship to. The first paragraph is 14. The purpose of section 155 and 156 is to avoid a multiplicity of trials where there are a number of accused. This is where essentially the same evidence on behalf of the prosecution is laid on charges faced by all the accused, is to avoid prejudice to both the accused and the prosecution. Paragraph 15. The court exercises the discretion to decide whether to allow a trial to proceed or order a separation of trials. The way this discretion has been exercised has been set out in S versus Ntuli and others. And I quote from that. In the exercise of its discretion, the trial court has to weigh up the likelihood of prejudice to the applicant accused resulting from a joint trial against the likelihood of prejudice to the other accused or the state if their trials are separated, and decide whether or not in the interest of justice a separation of trials should be granted. Prejudice there means prejudice in the sense that no injustice should be caused to the parties concerned, and that includes the state. The weight to be given to each of the relevant factors in the adjudication of this issue is for the trial court to assess in the exercise of its discretion. And then, Your Lordship, paragraph 16, Rex versus Heine and others, was a matter where 3 companies and 15 natural persons were charged with fraud committed over a period of 2.5 years. There, the case against the accused was that the accused consistently over the said period had acted in concert, created books and documents containing false entries and misleading omissions in order to deceive the police and auditors. It was held that practical considerations must decide whether it's permissible to charge a person with a course of conduct when he was done, consists not of an unbroken spell of uniform behavior, but of a series of closely following similar acts. These considerations require that in a proper case, a planned course of fraudulent conduct may be charged as a single crime of fraud, even if it might also be possible to analyze it into a series of separate frauds. It is true that the period was a very long one, and it appeared from the Crown case that not all the accused persons could have been associated with the course of conduct over the whole period of its existence. But that was not a sufficient reason for holding that they could not be charged upon a fraudulent course of conduct if they acted in concert to make a systematic series of fraudulent representations. Where the participation of several collaborators have not covered precisely the same period, particulars may be necessary to inform them of the existence of their alleged participation, but the Crown would not be precluded from charging them together on a course of conduct basis. In each case, it is necessary to decide whether there has been prejudice to the accused. In the present case, there has been none. Then paragraph 18. Your Lordship, that deals with the matter of Naidu. I'll go to Naidu. Your Lordship, let me just get S versus Naidu's citation for you, because there's also, very important, it was a racket. That's it, yes, Your Lordship. All right? But Naidu was also quoted in Maringa. Yeah. Your Lordship, the S versus Naidu's reference number is, citation is 2009, volume 2, SACR 674 It was a Gauteng Division, Johannesburg judgment. Right. The first paragraph there is paragraph 7, and dealing with the purpose of poker and racketeering. As explained from what has been quoted, in a nutshell, poker has been designed to deal with organized racketeering of entities irrespective of the particular parts played by the persons associated with such enterprise in achieving the object of the collective conspiracy to commit a particular crime and a series of crimes. And then also, Your Lordship, paragraph 12. However, paragraph 12, yes, of Naidu. I'm dealing with Naidu now, Your Lordship. I'm done with Maringa. Paragraph 12. However, it should be mentioned that in none of these cases was poker an issue. And that's referring to other cases where separation matters were dealt with. As can be gathered from what is stated below, the facts in all 4 of the quoted cases are distinguishable from those which apply in the present proceedings. Each of the 4 cases quoted, the various co-accused were charged with various offences, some of which could not be linked to all of them in time or by act or participation. It was submitted on behalf of the state that the situation is different in this case, as all the accused are involved in the same transactions which constitutes to the main count each of them faces. However, play different roles in achieving it. Your Lordship, in that same count is the racketeering count. Then paragraph 13 of the same judgment. The starting point in considering the issue in this appeal is the fact that the state case is postulated on the provisions of the various subsections of section 2.1 of POCA, namely that the various accused were all in different capacities involved in the illegal enterprise to which reference has already been made. Various criminal activities were undertaken, all having as their ultimate purpose the facilitation of various crimes referred in Schedule 1 of POCA for the benefit of the criminal enterprise formed by all the accused. In paragraph 14 of the same judgment, the evidence on which the state will rely as stated in the indictment itself and the summary of substantial facts attached to it, if proved to be correct, will justify the conviction of some of the various accused on a number of counts which may differ from those relating to other accused, depending on the specific activity of the other accused concerned. Paragraph 17. With the argument of the appellant's counsel loses sight in the fact that ultimately the charge against the appellants is one of racketeering and being part of a conspiracy to achieve a criminal result, whether it be theft, fraud, or the contravention of certain statutes and or regulations relating to the mining of minerals or customs and excise of currency controls. Paragraph 18. For each of the main counts and the alternatives thereto, there is only one set of facts which might result in the conviction of the main counts or the alternatives. What is clear is that in relation to each of the alternatives thereto, the evidence relied upon by the prosecution relates to the ongoing, continuous, repeated participation of each of the accused, and in particular accused 1, and the appellant in the illegal rackets in which they are all participants, despite the fact that the nature of the part played by each accused should be different from that of another accused. The evidence would remain the same to prove the conspiracy between them. And then paragraph 20, bearing the above considerations in mind, there is no possibility that any of the accused run the risk of being in a situation that any evidence led will not be relevant to the case he has to meet. Each of the accused is being tried for the same main offence. And then lastly, the last paragraph is 21, is necessary for the state to prove all the elements in the common law offences which makes up the illegal enterprise, which comprise the main charge against them before each can be convicted on count 1. In the circumstances, there can be no question of them claiming that they are not being charged with the same offence. The greater offence of necessity includes the lesser. Your Lordship, these cases, Maringa and Naidu, I fully dealt with in my heads of argument during the application. That when we originally argued the matter. Your Lordship, so I come back to the argument I wanted to make, is that racketeering matters cannot be treated the same as other cases when we consider the separation of trials application. There are a number of other considerations to be taken into account. Then, Your Lordship, I want to refer the court to the matter of Rodriguez versus National Director of Public Prosecutions and others. The citation is 2021, Volume 2, SACR 333, Supreme Court of Appeal judgment, and I specifically want to refer the court to paragraph 31. 31. Yes. It is firmly established that an application for the permanent stay of a prosecution should not be easily granted. In Sanderson versus Attorney General of Eastern Cape, the Constitutional Court pointed out that such an application has the effect of depriving society of presenting a complaint against someone who has transgressed its rules. This is such a central feature of any functioning democracy that it should never become diluted or distorted. On the contrary, any application for a stay of prosecution must be considered in the context of how it impacts the ability and the imperative of the state to carry out its important function. Lordship, the point I want to make is here, is that we have an obligation towards the community to present cases properly. And respectively, it's with respect that I argue that we've been deprived of that right to act in the best interest of the community when the separation of trials was granted. Lordship, then paragraph 27 of my heads of argument, it will be respectively argued that the Honourable Court erred in rejecting the applicant's argument that the second prayer became moot once it dismissed the first prayer.
No, it's not rejected.
Subsequently, the Honourable Court, Your Lordship, that's how I interpret it.
Then what happened when it became moot?
Your Lordship, let me maybe finish my argument, then your Court, Lordship, can ask me to address. Subsequently, the Honourable Court used its inherent powers in terms of Section 173 of the Constitution to accept that the absence of an application by the 6th and 9th respondents for a separation of trials in terms of Section 157 of the Criminal Procedure Act, as set out in the affidavits in the matter, constituted an application for separation. It will all be argued that it was not in the interest of justice for the Honourable Court to merit more to invoke the inherent powers in terms of Section 173 of the Constitution, where there were still other remedies, such as the correct application of Section 3428, available to the Court to resolve the issues pertaining to undue delay in the matter.
Perhaps, my Lord, I don't want to interfere, neither do I want to object. I'm trying to understand under which question that falls. Well, learned friend is, with great sort of respect, is babbling on and babbling on. But nowhere does this issue fall within the ambit of any question that he wishes your Lordship to reserve as a question of law for the consideration of the Supreme Court of Appeal. That's the court, please.
That those questions of law that
I invite, yes, with the greatest of respect, I invite your Lordship to look at the 5 questions and establish where the issue my learned friend is addressing now remotely is contained in any of those questions. It is nowhere, my Lord. As the court, please.
Your Lordship, I invite my learned friend to look at paragraphs 5 of the questions set out in paragraphs 5.4 and 5.5 of the application. Lordship, maybe just for the court, let me read it into the record now whilst we're at it. 5.4. Where the Honourable Court erred in mero motu applying its inherent powers in terms of Section 173 of the Constitution, instead of correctly conducting an inquiry in terms of Section 342 of the CPA. That's the question we propose, Your Lordship. Your Lordship, let me just finish. I'll give him the opportunity now, Your Lordship. And Your Lordship must remember, Section 319, this is an application between the state or the applicant and the court. And at the end of the day, what the state or the applicant is doing is, we propose certain questions. The court must then decide, I agree with the applicant, and I formulate the following question as suggested by the applicant. He can even expand on it or he can refuse it. But it's questions that's being put forward by the applicant where we feel or we believe there's questions of law that needs to be answered.
yes, you started with paragraph 5.4, which is the next one?
The next paragraph is 5.5, whether the Honourable Court erred in relying on Section 342 of the CPA, where he did not properly apply the provisions of the section and failed to hold an inquiry, providing all parties the opportunity to respond and provide due recognition to the impact of all parties, including the victim interest. Your Lordship, and I was moving towards that point when I was interrupted, so I want to know if Mr. Abrams has something further to say, or can I proceed?
I see. You have an opportunity to say something.
That's the court, please.
Yes,
Thank you, my Lord. The point we want to make is, Your Lordship, in terms of Section 342A. Your Lordship, when Your Lordship mero motu invoked Section 173 of the Constitution, it's clear from the judgment that the court did consider or have a look at Section 342A. The point we want to make is Section 342A is exactly in the Criminal Procedure Act where the court deals with issues of undue delay. And the argument we want to make is that before mero motu invoking Section 173 of the Constitution, the court should have first held an improper inquiry in terms of Section 342A of the Criminal Procedure Act, where all the parties address the court, and the court look at all the reasons for the undue delay, and then to make a finding, first of all, whether anybody is responsible for the undue delay, and if there's any fault. And then it goes further, Your Lordship. Once the court reached that point, then Section 342(3)(a) gives the court the powers to make orders to rectify the undue delays, or to address it and to curb it. And we are in agreement with this Honourable Court. There is undue delay in this matter. And the court did find in its judgment that the first and second respondents were responsible for that. It would be our argument also that it's the case. But the proper application or inquiry in terms of Section 342(a) would have provided the first and second respondents to properly reply and set out their case. And if all the evidence and all the material facts about the undue delay was considered and heard by the court, it would have provided the court with other options as well, other than a separation of trial or breaking up the case, to deal with the undue delay.
What proposition would that have provided to respect of those who have been ready to proceed with their matters since 2021?
Your Lordship.
What remedies do they have?
No, Your Lordship. It's for the court to manage the process, to set timelines, and to get all the orders. You see, Your Lordship, one of the things that we sit with is we have a submissions in the abstract that we are now petitioning the judgment of the court to refuse leave to appeal. But there's also other applications. That application is not here. It's not before this court. We don't know what it is. We've got an idea, we've been informed, but it's in the abstract. And the judgments are referred to you during my argument in the application, specifically said, or where the Constitutional Court and the Supreme Court of Appeal specifically stated that applications in the abstract must not be entertained. But Your Lordship could have made an order and said, listen, let's now get all the applications that you want to bring, let's deal with it, and then we set out a proper timeline for the trial management to deal with it. But what the court did was, the court decided, well, I don't know, we don't know how long it's going to take, it can take long. But if you look at all the judgments I referred to, and there's a number of them, Your Lordship, it states that it's the court's duty to manage the process. Don't kick for touch. It's the duty of the presiding officer to see to it that the trial runs and to see to it that all these issues are managed. Your Lordship, and it's not a submission, it's, as I said, our submissions are based on case law, where the Constitutional Court and the Supreme Court gave the guidelines how it should be done. Because now it becomes the state's problem. Your Lordship says in the judgment, there's no way that the state can curtail these things or can manage it. It's not our problem, Your Lordship. Now we are punished. The society at large are punished because the court decided there's no way that the trial can be finalized timelessly because of reasons which are postulated in the abstract. Now, the court issued a separation of trials. And at the end of the day, justice suffers because we cannot present the case as it should be done. And the interest of justice, it's not in the interest of justice, with all respect.
Does it call for you to proceed with the case the minute the court refused the first prayer of the applicant? Because you had said,
Yes.
once the court refuses prayer one, and prayer two is moved, why don't you proceed with hearing the matter immediately?
No, Your Lordship, because Your Lordship then granted the second prayer.
But the dear son is moved. So it was
No, Your Lordship.
granted.
Your Lordship and me and I don't have the same. And my argument was, the accused wanted the court to grant application for a temporary stay. And if that happened, then the matter would not be in a position to proceed. And then it was premised on that because of that delay that would be caused by the temporary stay, then it's not in the interest of justice of the other accused. But my argument was not, Your Lordship. My argument was that the moment the court refused the first application, the matter should have proceeded, because then there was no grounds for a separation of trials to be authorized. That's what I meant by moot. Because the grounds for the second application then fell away. Right. Your Lordship, paragraph 28 of my head will respectively argue that a court failed to exercise its discretion judicially or had been influenced by wrong principles of law or a misdirection of the facts, or whether its decision had been unreasonable in granting the separation of trials. And the arguments I've made is at the heart of this submission, Your Lordship, is that if Your Lordship properly considered the cases that I referred you to, the interest of society, the court would have come to another conclusion, that it would not be in the interest of justice to separate the trials. Right. So, Your Lordship, that deals with the first question that we've postulated. The second, then I move on to paragraph 29, Your Lordship. And the submission is that this Honourable Court did not consider or attach any due weight to the Prevention of Organised Crime Act of number 21 of 1998 and the authorities in relation thereto, as argued by the State at the time of the application. The preamble of POCA makes specific reference to the Bill of Rights and the Constitution, and why it's in the interest of justice to conduct prosecutions of this nature. Paragraph 30. The Honourable Court did not attach weight to the applicant's argument with reference to the relevant authorities that is necessary to take into account the factual basis of the State's case as set out in the indictment, as well as the implications of POCA, and why it's necessary to present a whole body of evidence in order to prove its case. Amongst other in this regard, and I address Your Lordship on that, the State versus Naidu. I'm not going to go through it again, but it is there in paragraph 30 of my heads of argument. In paragraph 31, the Honourable Court did not attach weight to the authorities that multiple proceedings should as far as possible be avoided I referred to your Lordship already to the case of Maringa. In that regard, also Rex versus Bagas, 1952, Volume 1, SA 437, S versus Schumann, another 1994, Volume 4, SA 853, S versus Nzuza, 1952, Volume 4, SA 8376, Appellate Division. Lordship, paragraph 32 of March, the Honourable Court found that the first and second applicants, through a succession of applications, delayed the commencement of the trial. It will respectfully argue, and that I've already done, that the Honourable Court at the juncture should have invoked Section 342A of the Criminal Procedure Act to deal with and prevent any further unreasonable delays. It is to be noted that the separation of trial does not fall within the remedies listed in Section 3423 of the Criminal Procedure Act. Paragraph 33. The Honourable Court did not attach weight in the applicant's argument with reference to the relevant authorities that the question whether the trial will be fair is ordinarily in the hands of the trial court. Proper trial management should cure potential prejudice. Prejudice may be rectified during the course of the trial, and the court may make preliminary rulings in aid of this objective. It's clear from the minutes of the case management meetings that the applications brought thus far by the first and second respondents, as well as the intended further applications, fell outside of what was agreed to. Your Lordship, then footnote 16, I refer you to all these cases where that I said deals with that it's the duty of the trial court to manage the process. The National Director of Public Prosecutions versus King, 2010, Volume 2, SACR 146, SCA at paragraphs 4 and 5. Thint, Pty Limited versus National Director of Public Prosecutions and others. Zuma versus National Directors of Public Prosecutions and others. 2008, Volume 2, SACR 421.
Are you dealing with the application of leave to appeal over Section 31 in the application?
Your Lordship, these are the issues that we say that the court did not follow the guidelines
You are dealing with
how to apply the, yes.
There's an application of leave to appeal.
Yes, Your Lordship.
But are we not dealing with Section 319 application?
Section 319 is based on the questions of law that has to be premised.
Why would you imagine that you would go to those 5 points that you...
Your Lordship, yes. Your Lordship, all I'm saying is, I need to make out why it's in the interest of justice that Your Lordship decide on Section 319.
But please deal with those points that you raised in Section 319. Otherwise, we're going to be here
Right?
until the council...
Your Lordship, in the application, paragraph 5.1,
Yes.
where is the first question that we propose?
Just deal with those aspects.
Your Lordship, okay, I'm going to go through the questions and then...
That's why Mr. Abrams now interjects when he thinks that we're not going to the right direction.
Lordship, question 1, 5.1. Whether the Honourable Court had exercised his discretion judicially or had been influenced by wrong principles of law or a misdirection on the facts, or whether its decision had been unreasonable in granting a separation of trial. Your Lordship, I think I've covered that. 5.2. Whether the Honourable Court duly consider the prosecutional prerogative as how to the accused should be charged as provided in Section 1792 of the Constitution. Lordship, I have done that. 5.3. Whether the Honourable Court erred in not considering the provisions of the POCA and the authorities in relation thereto when it interfered in the directive by the National Director of Public Prosecutions in terms of Section 2.4 of POCA. And I dealt with that, Your Lordship, and then there's the two last remaining questions that we proposed. 5.4, whether the Honourable Court erred in mero moto applying its inherent powers in terms of Section 173 of the Constitution instead of correctly conducting an entire inquiry in terms of Section 342A. I've done that. Your Lordship, and just for completeness sake, I'll just read the last question into the record before I make my final submissions. Whether the Honourable Court erred in relying on Section 342 of the CPA, where it did not properly apply the provisions of the section and failed to hold an inquiry providing all parties the opportunity to respond and provide due recognition to the impact of all the parties, including the victim interest. Your Lordship, now, in conclusion, it's my respectful submission that the questions of law have reasonable prospects of success, and that there are compelling reasons why the appeal should be heard before the trial resumes. Your Lordship, and I base that reasonable prospects of success because these issues have been previously considered as by the Constitutional Court and the Supreme Court of Appeal, where it interpreted in the same manner that the state is submitting to this Honourable Court. Now, this Honourable Court is then requested to reserve the above referred questions and direct that it be specially entered into the record and that a copy thereof be transmitted to the Registrar of the Appellate Division. Lordship, I don't know if there's any further issues you want to hear me on.
When you apply for leave to appeal, you have a choice, either to basically or to full court of mediation. And the section 131 gives you that option.
No, Your Lordship, it must go to the Supreme Court of Appeal.
Is it fair?
It is fair, Your Lordship. These issues, unfortunately, have a much wider impact. And Your Lordship will remember I addressed you on the whole Stalingrad approach. And there's a lot of cases that are suffering with applications and undue delay. And I think, and I submit that it's time that the Supreme Court of Appeal seriously consider these consequences and set guidelines as how the two should be dealt with and approached.
So you are happy that we have established the 5 points of law on those bases that should be referred to this.
That's correct, Your Lordship. I submit that we've met all the requirements. Thank you, my Lord.
You are number.
First and second respondent, my Lord.
Can you have a short break?
As the court please.
Court adjourns.